The DPP's lawyer backs away from sinking sand. What happened on day 3 of the hearing at the Court of Appeal in the DPP Retirement Age Case? Well, stay tuned. In my recap of day 2, which you should watch, I'll link it below. One of the things I said is that Douglas Lays, who is the lawyer representing DPP Paula Llewellyn, might find himself either on solid ground or sinking sand. This is because he said this act that the whole case is about, he said the act that said the person who was DPP at the time the act came into effect could elect to retire anytime after the age of 60. And his argument was that this didn't only apply to Ms. Llewellyn, it would apply to any DPP who came into office after Ms. Llewellyn. Now, I didn't really understand this argument because when you look at the words of the act, they seem really clear. Take a look here. So the act says, a person who is director of public prosecutions at the date of commencement of this act. And surely that could only mean one person, Ms. Llewellyn. Well, at the hearing earlier, Mr. Lays backed away from that sinking sand fast. He said to the court that he had taken another look at the act and he realizes, after all, that it could only apply to Ms. Llewellyn. Okay, good. Moving on. So, here's a little bit of inside court information. Did you know that there's a hierarchy of seating in the courts? Now, in the Supreme Court, I'm sure you know there are all these benches, right? So you have the judge sitting up top, and then down below you have a row of benches. The front bench is reserved for King's Counsel. Even if there are no King's Counsel in the court, that's where King's Counsel sit, or silk as they're also called, and they're referred to as silk because of the material that their court gowns are made of, unlike, regular cotton that us non-KC lawyers wear. So I've seen, for instance, in the Court of Appeal, when a big judgment was being handed down and the room packed, standing room only, lawyers lining all sides of the courtroom because the benches are full. And the lawyer who was in the matter got up and asked the court permission for some of the other lawyers to be allowed to sit in the bench reserved for, at the time it was Queen's Counsel. Judge said no. Judge said they must have something for aspire to. So there you go. So I've also seen some judges give permission though and say, yes, sure, lawyers can sit in the front bench. So if you're ever in the Supreme Court and you see this empty front bench in front and you're wondering why the lawyers don't move up, that's why they're not allowed to. It's King's Counsel bench. So Mr. Hilton now starts making his submissions. King's Counsel, so he's in the front row addressing the court. So I told you in a previous recap that Mr. Wood, representing the government, his position was the act was passed in accordance with the Constitution and therefore it's valid. Argument done. Argument done are my words. He never said that. But clearly that's what he meant. So Mr. Hilton now says to the court, you know something, if Mr. Wood is correct, if his arguments are correct, he should be able to sit down right now. But according to Mr. Hilton, Mr. Wood's arguments were plainly wrong. Those are his words. And Mr. Hilton used as an example the CCJ case, Caribbean Court of Justice case. Now, this is from the time when former Prime Minister P.J. Patterson had wanted to have the CCJ, Caribbean Court of Justice, as Jamaica's final court of appeal. So the government passed a law to replace the Privy Council with the CCJ. Even though that law was passed in accordance with the procedure that was set out in the Constitution, the matter went all the way to the Privy Council, and the Privy Council said, no, that's not enough. Sounds funny, not true. Law can be, trust me. Mr. Hilton also answered Mr. Wood's argument that there can't be an issue of separation of powers in this case. Now, Mr. Wood was arguing that because the legislature, that is Parliament, and the executive led by Cabinet are so closely intertwined, you can't have a separation of powers breach. You can't have an argument that one of them is interfering with the other. But Mr. Hilton said, no, we do have cases that show that you can have a breach between those two branches. Mr. Hilton also insisted that there is a principle that things should be done for a proper purpose. Then he said something interesting. He said the government side is making arguments as if we live in a country where there's parliamentary supremacy. So what does he mean? So in England, former colonizers, they have what they call an unwritten constitution. You can't go out as we can and, just buy a little book with the constitution in it from the government printing office or download it from the internet. They have what they call, as I said, an unwritten constitution. And in their country, Parliament is supreme, meaning Parliament is boss. So in the United Kingdom, you could never have a situation where a court looks at a law that Parliament has passed and strikes it down, saying it's unconstitutional. They don't have the power to do that because Parliament is supreme. In Jamaica and in other countries like Jamaica, our constitution is supreme. And that means that nobody, not even Parliament, can go outside of the constitution. That's why our courts can say, this law is unconstitutional, it's null and void and of no effect. So Mr. Hilton's argument was that the government side was acting as if, or has been making arguments as if Parliament is supreme, and that's just not the situation here. So then for a while, his colleague on his team, Kevin Powell, addressed the court. Kevin Powell, very well-respected lawyer, but not King's Counsel, yet calling it into being, Kevin. But so he addressed the court from the second bench, since he's not in King's Counsel bench. So Mr. Powell now was looking at this argument being made by both Mr. Lays as well as Mr. Wood, saying that the purpose of this Constitutional Amendment Act and the Section 2.2, which is a very controversial section, they were arguing that the purpose of it was to allow the DPP to be able to retire early if she wanted. Mr. Powell said, no, that's not necessary because when you look at the Pensions Act of 2017, he said Ms. Llewellyn qualifies under the Pension Act as an existing public officer, and therefore her rights to her pension and the possibility of her taking early retirement, he said those rights are protected under the Pensions Act. So he said, despite Mr. Lay's argument that the Pensions Act left Ms. Llewellyn out in the cold and unprotected, he said, not true. He said she indeed was protected under the Pension Act. Her rights were secured there. So the judges asked, but why should she, as an incumbent DPP, be shut out of the benefits of this increased retirement age? And Mr. Powell said, no, she's not shut out of the benefits at all, apart from the fact that she had already reached retirement age and already got an extension. So the judge said, but having got that extension, that meant she was still DPP. She was validly in the job and she wasn't getting a second extension. What happened is that she was benefiting from the new law by way of the increased extension. Mr. Powell said, well, that's going to relate to their argument as to whether or not Parliament was trying to go around the Constitution and grant Ms. Llewellyn a second extension. So I know we're going to be coming to that argument a little bit later on, so make sure you listen out for that. I think that's going to be very interesting when we see how that argument is made. All right, I just want to remind you, judges ask a lot of questions in these hearings, and that's because, they're trying to test the argument of the lawyers. They also, if there's something they don't quite understand or they think doesn't quite make sense, they are going to ask a lot of questions about it to see if the lawyers can fill in any gaps in their arguments. So these oral arguments, as they're called, when people stand up in court and, elaborate on the written submissions that they've sent in, are really, really important, especially if you hear the judges asking, what about this? What about that? They need to be, on their feet. They need to be on the game. They need to be on top of the material and really be able to explain their position to the judges. So then Mr. Hilton, it was time for Mr. Hilton again. They were alternating, Now, Mr. Hilton said the amending act, that's this controversial Constitutional Amendment Act, he said it breached two constitutional principles. It breached the principle of separation of powers. It breached the improper purpose principle. So he said the key issue that the court has to answer is, do these two principles exist in our Constitution? And did the Constitutional Amendment Act breach either one or both of them? That's actually two questions, but all right, you know what we mean. Now, Mr. Hilton also addressed the argument that Mr. Wood had made when Mr. Wood had said the courts need to look at just the plain language of the law and not taking all kinds of other considerations into account, such as the living tree principle. And Mr. Hilton said in response to that, that the court can and should look at different factors and different considerations when trying to make a decision about a particular law. Gonna have to leave it there for today. Thank you so much for joining me courtside. See you next time.